Welcome to Sakshi TV special immigration talk show with attorney Mr. Chan Parvathaneni from Managing Attorney of Sim Parvathaneni and Brown. Please note that Sakshi TV now has 4 immigration shows every week, every Tuesday with Srinivas Kaveti, every Wednesday with Prashanti Reddy in English, every Thursdays with Mr. Chan Parvathaneni in English, and on Fridays with Banu and Indra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at sakshi.com or call us at 8667257441. Before we begin the show, please note that the information provided on the show is not legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any legal advice, please contact the attorney directly. Mr. Chan needs no introduction, but if you need any consultation, you can log on to their law firm, svblawfirm.com site for any contact information. Without any further delay, let's welcome him onto our show. Mr. Parvathaneni, welcome.
Hello, Shivani, and thank you all Sakshi TV viewers for joining today. And hopefully we'll have a very good discussion on the H-1B and immigration updates going on in US.
Yes, we will have that, Mr. Parvathaneni. Welcome to our show again. But first of all, are there any new immigration updates that that were released this week, and so that we can continue with the topic?
Sure. There are a few minor updates. The major update is on the H-1B side. The lottery was over in March, and at the end of March, the selections were released. And this year, there were a large number of applications. The selection rate is very, very low. It's extremely low. And the filings have started. Starting from April 1st, the companies are now able to do their H-1B filings. So the actual H-1B filings have just begun. So there's another important news. It's a good news for a lot of students in India who are applying for the F1 visa or who want to apply for the F1 visa. So the new rule says that they can apply for the F1 visa, the student visa, 1 year ahead of their college start date. So previously it was only 4 months. They can apply for a F1 visa only 4 months before the scheduled college starting date. Now they have changed it to 1 year because I think USCIS, Department of State, they all understand that it is taking a very long time to get interview slots. So they are now allowing people to apply for a visa 1 year ahead of time. As far as coming into US, the things have not changed. The rules are still the same. It is only the application for the visa. So now you can apply for the visa 1 year ahead of time. And another thing on the student side, the F1 visas. So anybody that's on F1 visa in US, so now they can apply for their OPT cards, OPT employment cards in premium processing. This rule came out in March, but starting from April, everybody can utilize this rule to get their EAD cards faster.
Yes. So, Mr. Parvathaneni, you just said that the percentage of the H-1B selection are very low this year. So, why do you think this has happened suddenly, all of a sudden? Last time it wasn't as low as it is now. So, what are the possible reasons for this change?
Right. So, the bottom line this year is on an average, only 15% of the selection of the lottery registrations got selected. That is an abnormally low number. So 15 out of 100 registrations getting picked up in the lottery. That is very bad for a lot of companies because a lot of companies, like big companies like Microsoft, Google, they already have people on F1 visa on OPT status currently working for them. And now, when this lottery happened, only 15% on an average again got selected. A lot of people might not be able to continue to work anymore at these companies. So what exactly has happened? So the main problem is we only have 85,000 H-1B visas per year. And last year, 483,000 applied. So with that, probably around 30% got selected last year. And last year was a record number of registrations. This year, USCIS has not released their statistics yet, but based on the selections, because we know we have 85,000 H-1B visas, we know USCIS typically selects a little bit more than what we have. Last year it was they selected 126,000 selections. So based on that, if we kind of forecast, we probably got around 700 to 800,000 applications, 7 to 8 lakhs registrations. That is a number that USCIS has never seen in the past. That is a very high number, and we are not sure. People say that there are a lot of layoffs happening across the board, but seems that the tech industry, at least some part of the tech industry, is still pretty strong, and a lot of the newspapers, a lot of reputable news agencies, they did predict we're going to see a very huge increase in demand. And I mean, when everything is done, we are really seeing that we did get a lot of applications. So about 15% is what got selected. And unfortunately, a lot of people that did not get selected, it's pretty unfortunate for them. And hopefully USCIS does something about the way things are done. But right now, almost 85% did not get selected in the lottery.
Yes. So, Mr. Parvathaneni, we've recently heard in news that the USCIS is cracking down companies that are filing for multiple registrations. Is it really true?
True. So also, people, we are seeing a lot of demand for H-1B visas. That being said, there are always some bad actors who do multiple registrations. So what exactly is multiple registration? So multiple registrations is where two companies collude together, act together, and they file for the same employee multiple times. So basically what that means is company A is filing for that employee, company B is filing for that employee, company C is filing for that employee. And there are ways where when it is legal. But when somebody does something, when they are working in tandem, working in collusion to get some unfair advantage, they're doing something illegal. That is fraud. So because in reality there is no bona fide job offers, but they're just working together to increase somebody's chances in the lottery. So if people have done that, that is illegal, that is fraud. And what USCIS is doing is USCIS is being very aggressive in cracking down on multiple registrations. They have actually started this in the last 6-7 months. They're analyzing the H-1B registrations and they are issuing notices of intent to deny or notices of intent to revoke cases where they feel that companies have colluded together and filed multiple registrations. And it's very easy for USCIS to find out. Uh, this entire registration process is electronic, so they can analyze the data. They can look at the data. They can figure out if companies, the same set of companies, are filing for the same people or not. How much commonality is there? What exactly is happening? If they see common relationships, like the same company being owned by one person, the other company being owned by a relative of the same person. So the companies are related by familial relationships, or maybe through other relationships, maybe through their own data, where the data shows collusion. So when they're looking at doing various data analysis and figuring out there could be some kind of collusion, they are issuing notices of intent to revoke or notices of intent to deny. So USCIS has been doing that, and we repeatedly warned companies to be very cautious about the regulations, know the regulations, and ensure multiple registrations are not done. But unfortunately, there are always some bad actors. And at this point of time, we are still waiting for USCIS to release the data on the registrations this year. But one can be assured that they are definitely paying a very keen attention on the multiple registrations and multiple registrations as a whole. It is a nuisance to the H-1B process as a whole, because majority of the companies, they want to do things right. They want to get the job done by using talented employees. But unfortunately, when things like multiple registrations happen, it impacts the industry as a whole. And we have to see what USCIS would do down the line, because they did get a record number of registrations this year. And what that means is it is even more important that they make sure that all the registrations are bona fide and nobody is misusing this lottery process.
Yes. So, Mr. Parvathaneni, we're also hearing that USCIS is actually revoking the H-1B cases that were already approved. So, is that legally fine? I mean, I'm pretty sure there'll be a lot of problems coming up. So, what are your thoughts on it? Is that even legal because they're revoking the cases that have already been approved?
So USCIS has a policy where they say if an approval is in error, they can always go back and revoke that approval. So, but again, there is a process to do that. And the process is USCIS will never revoke H1 all of a sudden. What they will do is they will give a notice. They will issue a notice and they will say they'll make some allegations. They will say, this is what we are finding, and this is what we think it is, which is why we want to revoke the H1. And after giving that notice, they will give you enough time. And the typical timeline is 30 days. So they give 30 days to respond back to their allegations. So that is a time where somebody gets a notice of intent to revoke, and the companies have a chance to respond back to their allegations. And if they're able to satisfy USCIS, they will reaffirm the approval and they will not revoke the approval. But if they're not satisfied, then the petition will be revoked, because they will go back and claim that the initial approval itself was in error. And when that happens because of some fraud or misrepresentation, they have every right to revoke that petition.
Yes. Also, Mr. Parvathaneni, do you think there'll be a second lottery this year?
So last year, there was no second lottery. Last year, they only had a single lottery. And the year before that, they had 3 lotteries. They had the first phase, they had the second phase, and they had the third phase of selections. And the year prior to that year, they had only 2 lotteries. So what that means is, this is what will happen. So in the next 3 months, people who got selected in the lottery, the companies, they will be able to do their filings. And June 30th, that is the last day. And once June 30th is over, USCIS will look at their data. They will see how many people have applied, and they will be able to figure out how many people did not apply and how many free slots are still available. So in July, when they revisit and reanalyze their data, if they find a lot of people did not apply, they could do a second lottery. But if they find that enough people have applied and there are not many free slots, they will probably not do a second lottery. So historically, looking at how they have done things, a second lottery is definitely possible. It is not guaranteed, and until July, we will not be able to know if they will have a second lottery or not.
Yes. So, Mr. Parvathaneni, now that the H-1B lottery is done, what are some steps and what are some actual work that must be done to get the actual H-1B?
So the lottery is the first step. So whatever happened in March last month, that is the first step where the companies applied for their potential employees. The lottery was done. The selections are done. So now every company who has done a H-1B registration, they have their selections. So now is when the next process starts. So the next process, it's basically the company actually going back to USCIS and actually applying for the H-1B. They have 90 days to complete the process. And in 90 days, they have to do a certain set of steps before they apply. So the very first step starts off with applying for the LCA. So there is something called a labor condition application. And this is a document every company has to file with Department of Labor. The main purpose of this document is to let DOL know, Department of Labor, not USCIS, but Department of Labor. So Department of Labor needs to know where somebody will work, what is their occupation, and what are the wages that are being paid. So every company has to apply for this LCA. And based on that LCA, if the company meets the minimum requirements and attests that they will pay that minimum salary based on the work location, the first step is Department of Labor approving this LCA. And this LCA is a way of the government making sure that the US employees, the US workers, they're not disadvantaged by H-1B process. So when the company files for an LCA, promises to pay a certain wage and notify DOL of their intent, we are trying to make sure that the average US worker is not impacted by the US, by this H-1B process. At the same time, we are also ensuring that the H-1B workers are being paid the right wage. So this is the step one. This typically takes about 7 days. And now is the final step. The final step is taking this LCA, collecting a couple of documents from the employee, preparing the H-1B package, and sending that package back to USCIS along with the fees. So for the USCIS part, for every petition you have to pay a fee. So this is the critical phase, the critical step where you're collecting all the supporting documents and paying the fees and going back to USCIS, where the US Citizenship and Immigration Services, which is the body that adjudicates the H-1B petitions, the company is actually presenting these documents to them and giving USCIS an opportunity to look at the petition, look at the supporting documents, look at exactly what the job offer is, look at what the job duties are, look at the qualifications of the employee, and so on. And that is the process where needs to happen before June 30th. So typically, this entire process is about a 2-week process. So the companies are actually, they've already started this process. And this needs to happen before June 30th. And if this does not happen before June 30th, even if somebody is selected in the lottery, that lottery is wasted. So it's critical that this process is done. And once this process is complete, the next step is USCIS, they will issue a receipt. So the receipt copy is USCIS acknowledging that the case is in process. They're reviewing the case. And after one gets the receipt, between a month to 6 months, people can either get an approval or get some kind of a request for evidence. But what that means is the entire process can take anywhere between 1 to 6 months before the actual approval happens. And that is the time when somebody gets a H-1B approval.
Yes. Mr. Parvathaneni, let's discuss a little in terms of the cost. So, what do you think will a person need to, bear the expenses? So, how much do you think the whole process of the H-1B filing, till you get your H-1B visa, how much do you think it's going to cost around?
Sure. So the very first thing is, an employee can never pay for the H-1B filing costs. So if somebody tells a H-1B employee to pay the fees, it's illegal. Only the company has to bear the expenses of H-1B file. That is very important. And that being said, H-1B is a very expensive process. It is not cheap. It is a very expensive process. And again, the fees varies. So every company has a different fees, and there is a reason for that. So what USCIS has done is they've divided people into 3 different buckets. So there are 3 different fee structures for H-1B filing when they do the initial filing. If a company is a very small company, when they say a small company, a company that has less than 25 employees, they pay $1,710. So that is the minimum fee that anybody has to pay. But if a company has more than 25 employees, their fees shoots up to 2,460, so 2,460. And then they have a third fee structure. The third fee structure is they have to pay 6,460, but that is only if a company has more than 50 employees and more than 50% of their employees are on H-1B status. So if a company has majority of their employees on H-1B status, some of the companies might have to pay 6,460. So it is a very expensive process. And on top of that, you have premium processing fees. So if any company wants to get their H-1B approval very, very quickly, within 15 days, so they have an option. They can pay $2,500 and get a quick approval, quick adjudication. So that's an expensive fee that's added on top of H-1B fees. And then a lot of companies use attorneys. So there is an attorney fee, and an attorney fee averages anywhere between $700 to almost $1,500, depending on the attorney, depending on their fee structure, and so on. So overall, what that means is it's a very expensive process, and the company can expect anywhere between $2,000 to a pretty high number based on their number of employees.
Yes. So, Mr. Parvathaneni, now let's say that someone wants to apply a H-1B without an employer. So, is that even possible?
So H1. So there are some petitions in US where somebody can self-sponsor, but unfortunately for H-1B, H-1B is a petition where you always need to have an employer, and only an employer, a US employer, is the one that can file for a H-1B. So what that means is an employee will not sign on the H-1B, and an employee cannot self-sponsor them. Only a company can sponsor them, and what that means is the company, a valid US employer, will have to file a form I-129, will have to sign off on the form I-129, saying that they're sponsoring the beneficiary, the employee. They also have to file a LCA. They also have to attest that they will abide by the terms of LCA, sign the documents, and send it to USCIS. And typically, for a H-1B petition, the employee will not sign anywhere. It is completely an employer petition. So unfortunately, even if somebody is highly qualified, you cannot really use H-1B unless you have an employer who's willing to sponsor you, and they have a bona fide job offer.
Yes. So, Mr. Parvathaneni, can one apply through some employee? So, let's say he has applied from one employee, employee number one, and now he wants to change and transfer it to another employee because there was some issue. Let's say that he decided to change the job or change the employer. Is that possible? And also, if yes, what is the process for it?
So I mean, when you're talking about the lottery process, the CAP registrations. So what happens is when you get a selection, the registration selection, the selection uh, uh, only the employer can apply. The reason is when once one is selected in the lottery, the selection notice will have the name of the employer. And USCIS, to ensure that there is no fraud, they want to make sure only the company that has filed the H-1B in the registration process, only the company that has a bona fide job offer, only that company is applying for the employee. So what that means is they want to make sure there is no fraud. So only whichever company has filed should be able to apply. So they kind of make sure they're putting that company's name in the H-1B selection notice. And when the I-129 gets applied, USCIS is actually making sure they check the I-129 with the selection notice. And if the selection notice, the name of the company doesn't match, they will reject the filing. And what that means is you cannot do a transfer. So normally for H1, if somebody is already on H1B, they can do a transfer. But unfortunately for the selection notices, you cannot do a transfer. And if some company, after the selection, they decide not to apply, the beneficiary is stuck. The beneficiary has to wait again until next year, again find a new employer, but they cannot transfer the selection notice to a different employer.
Yes. So, Mr. Parvathaneni, are there any travel restrictions for people who are filing for the H-1B? So, can an employee or let's say the employee only, can they travel when the whole process is still going on?
So there are some travel restrictions for this entire this CAP H-1B process, and everybody has to make sure they know the rules. The reason is if anybody is in US already in US, there is a big because this H-1B approval it is from October 1st. So whatever we are doing right now after the lottery, the petitions are requesting a start date of October 1st. So between now and October, a lot of people who are in US they might want to travel, and it always happens that somebody has an emergency where they don't have a choice; they have to travel. So anytime anybody has a travel plan after their H-1B is filed, definitely make sure you talk to your attorney or your employer because there is a rule that says anytime anybody applies for a change of status, one cannot leave the country until that change of status petition is approved. Otherwise, what will happen is the change of status part will get denied. And this applies to, say, people who are on F1 visa in US, students, or H4 spouses. So if anybody on F1 or H4 who are applying for H-1B, if they have to travel out of the country after their H-1B is filed, the H-1B change of status will get denied if you travel. So make sure you talk to your attorneys. So there are ways. So the way is you ask for consular processing, you go for visa stamping. That is the way. But because we have this problem, you always have to make sure you talk to your attorney or your employer so they know what is happening. And accordingly, they can make sure they file it under consular processing or they can advise you for consular processing. But absolutely, if USCIS finds out there is travel for whatever reason, they will deny the change of status requests.
Yes. Mr. Paratheni, I'm pretty sure there will be some kind of typographical errors anytime. I think these are some common mistakes that people tend to do when they're filing. So, does these kind of errors really affect something when they are applying for an H-1B?
Sure. So every year we face a situation where when people are registering for the lottery, they make some minor mistakes in their name. Maybe they interchange their first name, last name. Maybe they misspelled the name. Maybe they forgot a single letter in a name. Maybe they made a typographical mistake with the date of birth. especially because the date of birth in India, the format is different. We use date first in India, we use month first in US. So we always have these minor typographical mistakes. But this is the rule. The rule is we do have the burden to show that whoever is the person selected in the lottery is exactly the same person that we are doing the filing. So what that means is whenever the typographical mistake is a very minor mistake, we normally what we do is we correct it in the I-129 when we do the H-1B filing, and we let USCIS know it's a minor typographical mistake. They do have a discretion, but again, as a whole, when they look at the registration, look at the passport number, look at things as a whole, uh, most of the time they do forgive minor mistakes, and we never had a problem in the last couple of years where minor things were wrong. However, if things are major, something like the passport number is different, the name is different, tomorrow they cannot really say it is the same person. So for those kind of things, USCIS could reject the cases. So last year we had a case where somebody got married. So between the time we did the registration and the time we did the filing, the person's last name changed. And unfortunately, at the same time, they also had to apply for a passport. So the passport also changed. So USCIS returned the packet back to us and said, it looks like the person is different. It's a different name altogether, different passport altogether. But luckily, we were able to send the packet back and again clearly explain it to them that it is the same person. They married. So here, look at their marriage certificate, look at their old passport that matches, look at their new passport. So they were convinced and they were able to proceed further. But what that means is, as long as you're able to convince USCIS that it's a minor mistake or it is the same person, they will accept the case. So depending on that, more than likely, if it's a minor mistake, they should not have a problem.
Yes. It was wonderful, Mr. Parvathaneni, to have you on our show again. Let's continue this again next week. Thank you for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.